Wabarakatuh. Very good afternoon, ladies and gentlemen. Welcome back to our convention after our lunch break. So we trust you have enjoyed the delicious refreshment and also had a fruitful visit to the exhibition area. So ladies and gentlemen, this afternoon we are honored to be joined by Yang Berbahagia Datuk Nur Azmi bin Muhammad Narawi, the Director General of the Legal Aid Department Malaysia, along with our distinguished delegates from ASEAN. So your presence adds great value to our proceeding and we're truly delighted to have you with us. And on a special note, we extend our warmest birthday wishes to Yang Berbahagia Datuk Nur Azmi. May your leadership continue to inspire excellence and innovation within the Legal Aid Department Malaysia. Selamat Hari Lahir Datuk. Happy birthday to you. So ladies and gentlemen, for those joining us virtually, we are pleased to share that our convention is streaming live on the official Facebook page and also the YouTube channel of the Legal Aid Department Malaysia. So do share the link and let others be part of this meaningful gathering. So ladies and gentlemen, now without further ado, let us welcome our moderator for our next session, who will guide us through the upcoming discussion with insights and expertise. Ladies and gentlemen, please welcome our moderator, Madam Anissa Norma Muhammad Noor. She's the Director of Legal Aid Department, Selangor. And please welcome our speaker from Public Defender's Office, Singapore, Mr. Ashwin Ganapati. We have a very strong support from Singapore. Next, please welcome Public Attorney Officer of Philippines, Dr. Persida V. Rueta Acosta. Next, please welcome Attorney Erwin P. Erfe, MD. From Bar Association of the Kingdom of Cambodia, Attorney at Law Srun Tirith. And from Legal Aid Department Malaysia, please welcome Puan Zulfazlia binti Mahmud, State Director of Legal Aid Department, Pahang. We also have a very strong support from LED members at the back, Madam. So without further ado, ladies and gentlemen, I pass this session to our moderator, Madam Anissa Norma Muhammad Noor. Please, ma'am.
Thank you, Mr. Moderator. Assalamualaikum warahmatullahi wabarakatuh, and very good afternoon to all distinguished guests, speakers, and participants. Hi, my name Anissa Norma Muhammad Noor. Anyone can call me Anissa, and I'm thrilled to be moderating today's discussion. Yes, we are still in the same topic as earlier before we had our delightful lunch, that is civil and criminal child legal aid initiatives. Today, we will begin with short presentations from our distinguished panelists, and we will conclude our discussion with audience on the floor questions, if any. Our goal is to have a lively and insightful discussion and leaves you better informed and inspired with today's topic. Ladies and gentlemen, I might be promotes this quote to every one of us. Every child begins life innocent. If they learn to hurt, it's because they have been hurt. Heal the child, don't blame them. With that, allow me to introduce our lineup expert panelists to explore how every country to help those children who lost their childhood better way and fell into criminal trouble to get access to a legal aid. The first on the right, the most experienced person in Singapore Public Defender's Office, that is Mr. Ashwin Ganapati. Mr. Ashwin, acting as a Senior Assistant Director, Criminal Defense at Singapore's Public Defender's Office, Ministry of Law. And Mr. Ashwin had approximately 10 years of experience in criminal defense litigation in Singapore. Hi, Mr. Ashwin. Welcome to Malaysia, and I'm sure that you are eager to present for our discussion today. Obviously, thank you. Secondly, we are honored today to have two representatives from Philippines. I would say we are fortunate to have a great and experienced lady to present about legal aid and human rights. Let me introduce Dr. Presida V. Reda Acosta. Dr. Presida has served as a Chief Public Attorney of the Public Attorney's Office, which is also known as PAO, in the Republic of Philippines since February 23, 2001, across four presidential administration. My mistake. For all of us information, her dedication as a mentor and her successful lobbying for Republic Act number 9406, which elevated PAO to an independent and autonomous office, are highlighted as significant contributions to public service, legal aid, and human rights advocacy in Philippines. Hi, Dr. Presida. Hi. Welcome to Malaysia, and thank you for having time with us today. Thank you. Next to Dr. Presida, we have the most gentleman guy on the stage, isn't it? I introduce Attorney Erwin P. Erfe, also known as Dr. Erwin. Currently, Dr. Erwin acting as Deputy Chief Public Attorney, DCPA, of the Public Attorney's Office and concurrent Director General of PAO, Forensic Laboratory Division. And he is a both lawyer and registered physician. He has successfully passed the Philippine Bar, Philippine Physician Licensure, and United States Medical Licensure examination. Hi, Dr. Erwin. Welcome to our discussion today. And hope you have a great moment in Malaysia for the past few days. Is it? Thank you. Okay, next to Mr. Erwin, we have the most sweet and gorgeous man. Let me introduce Mr. Srun Siri from Bar Association of the Kingdom of Cambodia. Mr. Srun currently is a professional lawyer at SVP Law Firm and serves as the Director of Public Relations and International Cooperations at the Bar Association of the Kingdom of Cambodia. And areas of expertise of Mr. Srun covers on environment, investment, physical infrastructure, governance, and human rights, obviously, right? That's why he will call for today. He will call for today a discussion. With regard to his Asian legal profession involvement, Mr. Srun also member Asean Law Association Cambodia, ALA Cambodia, and heads its specialized task force and legal information. Hi, Mr. Srun. Welcome to Malaysia, and thank you for joining us to share your thought and experience in this convention. Thank you again. Last but not least, the nearest panel with me, our final panelist for today, I would say the calmest lady, but yet full of experience, isn't it, from the face? Thank you for the support. Here we have Mrs. Zul Fazliah Mahmud, who has an influential voice on the topic of legal aid initiatives in Malaysia from Malaysia Legal Aid Department. Currently, Mrs. Fazliah acting as State Director of Pahang Legal Aid Department Malaysia, but previously she was the State Director of Legal Aid Malaysia in Terengganu, whereas Pahang. And before that, she also specialized as a legal companion for child sexual assault victims, handling children aged 5 to 16 years old and victim of incest together with rape and sexual assault. Okay. Let's give a round of applause to our fantastic lineup of expert panelists today. Ladies and gentlemen, I'll be here to guide the discussion and presentation, keep us on track, and ensure everyone has a chance to participate. Before we begin, just a quick note, this is a guided discussion with a question will be taken from the audience, and if there are any questions from the Slido, we will take it from there. Okay, if any. We will starting our discussion promptly and finish on time. We tried. With that, let's begin by hearing presentation from our first panelist, Mr. Ashwin Ganapati, which talk about youth and criminal justice system in Singapore.
I was minded to correct Madam Anissa that I was the most experienced lawyer in Singapore. But I thought about it, it feels good to be known as the most experienced lawyer. So please remember me as the most experienced lawyer in Singapore. I'm also very mindful of the time. There's a big clock right there telling us how long we have. Like my previous counterparts from Singapore, I will try to be on time, I'll finish on time. But if I don't, just know it's a me problem and not a reflection of Singapore's efficiency. Now with that, ladies and gentlemen, thank you for allowing me to be here. My name is Ashwin Ganapati. With me is Mr. Ryan Nonis sitting over there. Both of us are from the Public Defender's Office. Today's topic is about the youth and the justice system in Singapore. Now, before I go into my presentation proper, I don't think it will be an exaggeration for me to say this. For every society to function, there must be law and order. The rule of law must be obeyed. Without the rule of law, societies will plunge into chaos and anarchy. It is for this reason Singapore has a reputation for being tough on crime. But with that being said, we also recognize at the end of the day that there is a particularly vulnerable class of persons amongst our midst, and these are our young offenders. Now, the reason why I've started off with this preamble is because it gives me a good roadmap as to what I'm about to present. Next slide, please. Now, these are just some statistics from our Ministry of Social and Family Department. You can see that our youth offending rate has remained quite low. I was unable to pull out the 2024's statistics, so you'll have to make do with what I have at this point in time. But the good news is that the offending with regards to young offenders are at a low so far. But there is a worrying trend. If you look closely, you can see that sexual offenses has gone up, offenses with drug trafficking, drug offenses in particular, has also gone up. This presentation will basically talk about three parts. The first is the preemptive measures to work with youth at risk. The second is the pre-charging stage. And the third is the rehabilitative sentencing measures in courts. Let me start off with the first topic. Preemptively engaging with youth at risk. Now, from our experience, we have identified certain risk factors that actually show and are actually prevalent in youth offenders. One of them would be absenteeism from schools. We have come to realize that if we keep our youth in school, we keep them engaged, chances of them straying away becomes that much lower. As they say, an idle mind is a devil's workshop. So it's for this reason that Singapore also came up with what we call is the Uplift program. Now, it started off as a pilot program, but it started off with a pilot program with just 3 towns, and as of 2023, has now expanded nationwide. So essentially what happens is that in this kind of situations, social workers will identify very young school students per se, who have been shown to be being absent from school. With that, what they'll start to do is that they will identify these students, they will bring these students for counseling, and they will understand why these students are missing school. A very key part of it is, and at least this is from my experience, a very key part of it is when we look at the inner circle of these students, we will find that the family structure is sometimes compromised. So the social workers will also work very closely with the family structure to perhaps try and to keep their child in school. With that focus in mind, it is our experience that children are less likely to commit offenses. There are also other particular programs at place, and that's what we call the Youth Go program. It's not on this slide. but I just realized there's another program called the Youth Go program, where social workers will actively go around hotspots, and if they spot youthful, I wouldn't say offenders, but youths hanging around very late at night, they will take note of these youthful children and ask them, and just go through the entire rigmarole of asking them as to why they're staying up late, and they will take the initiative to contact teachers and their parents to let them know that they should remain in school. I can tell you that this is actually quite a scary experience. A long time ago, I was also hanging out late, and I recall a youth officer actually coming up to me and asking me why I was hanging out very late. And when I asked him, I said, "What are you going to do?" And if he said, "I will tell your mother," I think that got me thinking very hard. Facing my mother was definitely way more scary than facing the police. Now, I want to go on to the next point. The next point is what we call the pre-charging stage. Now, youths in Singapore, like every other offender, when arrested, are afforded certain rights. But they will also have to go through the same investigation process. However, we also recognize that youths in Singapore, and I'll say youths in particular, it can be a very daunting and harrowing task of facing investigation officers all alone. It is for this reason, in 2017, Singapore came up with the Appropriate Adult Scheme. So the Appropriate Adult Scheme is a scheme where if an offender or an alleged offender has been brought in for questioning, he or she will sit with the alleged offender throughout the investigation statement taking. The purpose of the appropriate adult is to ensure that the child is mentally stable, is emotionally stable when giving the statements. Because false confessions can arise when a child is too fearful of the police officer. I think I don't need to go into the mechanics of that, but it is as obvious as it gets. The appropriate adult is important because not only does he or she ensure that the child is fine, it also ensures that the statement taking is done properly as well. This way, we protect the child in ensuring that their rights is also afforded. Now, another part that I'd like to talk about also occurs at the pre-charging stage, and this is what we call the divisionary programs. I'll be very brief on this because I can see the clock. It's really ticking quite fast. So at the pre-charging stage, we have also come to realize that sometimes it is better to steer the kids away from the court system. We give them the chance that they need to rehabilitate, and we do this through certain programs that we have in mind. For example, it's what we call the Youth Guidance Program, GP for short. So in this scenario, let me give you an example. Say we have an alleged offender who comes to station. He is being investigated for a relatively minor crime, theft, for example. The investigation officer, instead of charging this person, will ask that the young offender goes through a youth guidance program. It's about 6 months, where a social worker will be assigned to the said offender, and the social worker will go through various counseling programs, will go through various therapeutic programs as well, and will try to identify the risk factors that are apparent in the said child. After 6 months, if all is fine and dandy, and the social worker says that the child is good to go, the police officer, on the advice of the Attorney General, will issue a conditional warning against the offender. This way, we keep the young offender from the courts. Now, at the start of my presentation, I had mentioned that there is a worrying rise of sexual offences, drug offences, insofar as youth offenders are concerned. Singapore also has curated programs for such offenders as well. So when it comes to, say, for example, a youth who has been accused of drug trafficking, we have social workers and counsellors assigned to this child, and they will do the necessary to put this child back on the right path. So it's not just a general sense, but it is curated to specific offences as well. Now, the last part I would like to talk about, let me just go to a particular slide where it shows the statistics for the divisionary programs. As you can see, the stats are actually quite good, the numbers are quite good, there is a good improvement, there are a number of young offenders who have gone through the guidance program, and the numbers are rising, so which is good. The completion rate is good, and we are keeping more children out of the court system. I'll now go on to the sentencing options. I'm going to talk about three main sentencing options available in our sentencing courts. That would be probation, reformative training, juvenile rehabilitation centers, and community-based sentences. My focus will be just on the first three. Underpinning all four sentencing options is the principle of rehabilitation. I can do no better than to perhaps echo the words of our former Chief Justice, Mr. Yong Pang Hao, in the very seminal case of PP versus Maurice Mock. This is what His Honour said. Young offenders are in their formative years, and the chances for successful rehabilitation are better. Compassion is thus shown to them on the basis that the young don't know any better. As you can see, all of these sentencing options are geared towards one thing, that is to rehabilitate our young offender. There is no greater public interest than seeing our young offenders rehabilitated and becoming contributing members of our society. Let me start off with probation. Probation is a situation where an offender has been charged with an offense. It can be relatively minor, it can also be serious, which I'll come to in a bit. The focus of the the focus of probation is to keep the young offender out of the penal system. It focuses on ensuring that the offender is rehabilitated through various causes and therapy sessions as well. They can be as stringent as 12 months, or last as long as 12, no, it can be as short as 12 months and go all the way up to 36 months. At every step of the way, a probation officer will monitor the accused person's movements. For example, if curfew is emplaced, then the particular person has to be home by a certain time. Probation is a critical tool in ensuring that our young offenders are out of the penal system. There is a I think most of my colleagues here from Singapore would know this case. It's a very important case, PP versus Justin Heng. Now, this case involved a young offender who was charged and convicted of 4 drug trafficking charges, I believe. And in a rare move, the court, District Judge C.K. Un, as he then was, imposed probation. Now, I know Justin Heng on a personal level, and he successfully completed probation, and he went on to become a Justice's Law Clerk in the Tasmanian Supreme Court. And this just goes to show just the powers, when we give our youthful offenders a second chance that they so need, desire, and crave, they can do wonders with that chance. The next sentencing option that I'd like to talk about very briefly would be the JRC. Now, a JRC may be ordered where the youth is deemed unsuitable for probation and/or is determined that the youth may benefit from a more structured environment. This may be in scenarios where the home environment is not conducive for the rehabilitation and the discipline of the youth. But there's one drawback to the JRC. Once the accused person reaches 19, he or she would have to leave the JRC. It is for this reason, at least from my experience, the JRCs are not usually utilized. In turn, what is utilized would be reformative training. Reformative training is the most dreaded punishment a youth offender will tell you. He will tell you all sorts of things. He will tell you, sir, I'd rather face jail. You put me in jail 3-4 months, I'd rather do that. You give me caning, I will also take, but please do not put me in reformative training. Reformative training is a measure in place in our system where there's a much more structured program involved. For example, the youth will undergo various drills, disciplinary measures, and at the same time, undergo various counseling sessions as well. Reformative training is generally imposed on offenders convicted of more serious offenses, but not serious enough for our regular imprisonment. The aim is to ensure that the offender does not mix with the general prison population, where the influences can be strong and the influence can be negative. So our reformative training in that sense is somewhat, you are incarcerated, but it's not jail in that sense, because you do not benefit, you have the benefit of all sorts of rehabilitative programs. The reformative training regime is generally about 6 months. It's what we call level 1 intensity, and can go up to a minimum of 12 months level 2 intensity. Prior to this, it was a flat rate of 18 months intensity, right? So with recent amendments, it has now become 6 months and 12 months. Once an accused person has completed his reformative training, he or she will be released and will be placed on the release on supervision team, where they'll be monitored for a couple of years before they finally complete your sentence. So it's not a matter of you just finishing your sentence and coming out. There will still be proper monitoring to ensure that you are truly rehabilitated. So with that, ladies and gentlemen, I think I've come to the end. I'm right on time, I think. But since I have 30 seconds left, let me just say that I'm particularly grateful to the earlier panelists who are here. I have learned a lot, especially from my colleagues and from my counterparts from Vietnam, Timor-Leste, and Philip, no, can't remember. Yes. And I'd like to say that I'm grateful for the time that you've given me, and for that, thank you very much.
Welcome, Mr. Ashwin. Let me thank you for the thoughtful presentation by Mr. Ashwin Kanapati just now. Now we move to Dr. Presida, but before we proceed, allow me to add on some background and contributions of Dr. Presida, if any. Okay. Dr. Presida was the fourth placer in the 1989 bar examination and has completed executive programs at Harvard Kennedy School, acquiring certificates in financial management from HKS and international management and leadership from the International Center for Parliamentary Studies in London. Her expertise in legal aid and human rights advocacy is recognized internationally, leading to invitations and experts and resource persons from various institutions like UNICEF, UNODC, UNDP, and legal aid organizations worldwide. She has participated in numerous international speaking engagements and conferences on legal aid, human rights, and corrections across various countries, including Australia, China, Taiwan, Thailand, Indonesia, Vietnam, South Africa, and Australia. Without further ado, I'd like to welcome Dr. Presida to present on defending and protecting the legal and human rights of children, the Public Attorney's Office. Where the floor is yours, Doctor.
The honorable organizers of the 2025 Asean Convention on Legal Aid for Children, sir, participants, delegates, ladies and gentlemen, a very pleasant good afternoon to everyone. My fellow speaker, Dr. and Attorney Erwin Erpe, our concurrent Deputy Chief Public Attorney, my right hand, as well as the head and director of our PAO Forensic Laboratory Division. We both are honored to have been given this opportunity to share with you our office advocacy for children in conflict with the law, as well as the victims, the child victim. Okay, slide number 4, please. On this slide, we have here a big background about our office, the Public Defender's Office or Public Attorney's Office, where yours truly has become the head of this since 2001 or almost 25 years ago. The Public Attorney's Office is the principal office of the government in extending free legal aid to indigent persons in criminal, civil, labor, administrative, and other quasi-judicial cases. But we can be called upon by government authorities to render such service to other persons, even to taxpayers, in case of emergency legal aid. Regarding our number of cases last year, our clientele totaled to 15 million Filipino people. And we have handled 847,317 cases. We have a grade of 83.63% favorable disposition rate. And of course, recently, we were given an outstanding grade by our Office of the President and our Department of Budget and Management. As far as the children in conflict with the law, our beneficiaries in 2024, last year, totaled 18,925 children in conflict with the law as well as child victims. You can see how overworked we are. Our lawyer is about less than 3,000 nationwide, And we have 1,000 support staff. We have 300 plus district and regional offices. We have young minor clients, of course. They are the victims of crimes, children in conflict with the law. And we have a law, Republic Act number 9344, entitled as Juvenile Justice and Welfare Act of 2006. You know, the UNICEF has funded our training seminar for about 12 years, and then our lawyers has been trained to handle this delicate job to defend and to assist children in conflict with the law. And then there is Republic Act 10630, wherein the minimum age of responsibility in the past for several years since Spanish time, if you are 9-year-old, you can be incarcerated. But now, 15 years old. It was higher age of culpability. And this is, of course, with the effort of UNICEF and other UN bodies. And this representation also helped so that those 15-year-old and below can be diverted, can be trained and rehabilitated by our social workers. And then we have the 9344, the act, as I've said. We have the Juvenile Justice and Welfare Council. And our office is the prime stakeholder, duty bearer, to assist our children. And then there is a procedure for taking the child into custody. And there's a procedure in our law. And then we have duties during initial investigation, the taking of statement, and of course our lawyers and social workers are trained psychologically, mentally, physically, so that we can give justice to our children. Of course, our children are our future. We should treat them well and let them lead the way. That's a song. Of course, now we have many illegal initiatives so that we can protect and defend the rights of children who are victims of crimes and those who are children in conflict with the law in relation to the civil, criminal cases. We have the PAO Forensic Laboratory Division, second, memorandum with our Social Welfare Department. We have rehabilitation, diversion, and youth facility and visitations. We have our assistants during inquest, 24/7. We always there to assist our children. And because of the pandemic, your chief public attorney has been active in Facebook, YouTube, and other social media so that we can extend legal counseling and information dissemination program live via FB, via social media. And this is every Friday. You know, there is a legal maxim, ignorance of the law excuses no one from compliance therewith. So we should inform the public, the people of the world, as well as the foreigners in our land, so that they won't be incarcerated because they are ignorant of the law. Everybody should know what are the old laws and what are the current laws to avoid any legal conflict. And now, ladies and gentlemen, let us hear from our Director of our PAO Forensic Laboratory Division and the newly appointed Deputy Chief Public Attorney, Dr. and Attorney Erwin Erpe. Thank you.
Thank you, Dr. Basida, for the nice presentation just now. I'm pretty sure that Dr. Erwin would like to continue sharing what next on venture and efforts of the Philippines Public Attorney Office. The floor is yours, Doctor.
Good afternoon. To continue with the presentation, can we flash the presentation? Yes. The Forensic Laboratory Division was established in 2010 as a support service to our public attorneys. We harness the knowledge in forensic science as well as in forensic medicine to help our lawyers assess their cases and present their evidence in courts. In the past years, we have used criminal incident reconstruction. We have also used methods in forensic anthropology such as biological profiling in identifying a 5-year-old skeletal remains. We have also used bullet trajectory studies, forensic autopsies, forensic archaeology, in our evaluation of evidence. No? Now, we have rendered assistance to victims of child abuse, extrajudicial killings, wife battering, also sexual molestation and torture. The laboratory was actually in response to several laws that were enacted the previous years. Like, for example, the Anti-Violence Against Women and Their Children Act of 2004, and then the Anti-Rape Law, as well as the Anti-Torture Act of 2009. We also used to mention the alternative light sources in order to identify injuries of children as well as sexual abuse victims. So we have used ultraviolet light and infrared light to see injuries that occurred 3 months prior to the examination. We have also used ultraviolet light to victims of rape and sexual abuse. We have entered, the Public Attorney's Office entered into agreements with several organizations. What is most relevant now is our Memorandum of Agreement with the Social Welfare Department, where the public attorneys provide legal assistance to victims of violence against women and children, as well as children in conflict with the law. We have also assisted the local prospective adoptive parents who wish to adopt their own child or stepchild in order to improve the latter's status. We have also assisted those single parents who wish to ask for legal support for themselves and their children. Next slide. Public attorneys conduct regular visits to their clients, their children clients, in rehabilitation centers as well as in youth facilities. Next slide, please. There was an earlier discussion regarding the use of hotlines. The Public Attorney's Office have hotlines where they provide, public attorneys provide legal counseling as well as assistance during office hours, after office hours, weekends, and holidays. So it's a 24/7 support service. We have leveraged the use of newspapers, information dissemination through our newspapers. Our Chief Public Attorney has several columns, legal advice columns in newspapers. We have 4 on this particular slide. Next slide, please. We have also used or leveraged the use of social media. Our Chief Public Attorney has accounts or web pages in Facebook. She has a live show in Facebook called the #Pala, or the Presida Acosta's Legal Advice, which is aired both in Facebook as well as in YouTube. We have some representative cases which shows the breadth of the cases that we have handled in the past. The case of the child KM, which she was actually denied the issuance of good moral character, which is a mandatory requirement for entrance into a university. Through the legal assistance of the Public Attorney's Office, the Court of Appeals issued a writ of preliminary mandatory injunction and compelled the school to issue a good moral character certificate. The child has since graduated and is now a certified public attorney. We have another case of a victim of verbal abuse by the child, by the teacher of the child. And she suffered psychological trauma, underwent treatment, and through the mediation efforts of the Public Attorney's Office, the child transferred school through the help of the Department of Education. Next slide, please. These are some of the pictures that some of the controversial cases that we have handled, the extrajudicial killings of children in the Philippines. You can see here the Chief Public Attorney examining the crime scene, and myself conducting bullet trajectory studies on the body of the victim. And then on the third picture shows the victim lying prone. We have proved through our examinations that the child was killed in a prone position, and there was no encounter. Next slide, please. That's me testifying in the Senate of the Philippines, demonstrating how a child was killed by the police. Next slide, please. The police involved in this case was adjudged guilty by the court of murder. Next slide, please. Then there are other cases of extrajudicial killings of children. We have conducted forensic examinations on their bodies. I testified in court, and the policeman involved in the torture and the murder of these children were subsequently convicted and sentenced to 40 years in prison. Next slide, please. There were other cases which were referred to the public attorney's office, like, for example, this child who died after circumcision. We performed a forensic examination on the body of the victim, and that formed the basis of the mediation that was held later on in preparation for litigation. Then there was another case of possible negligence committed by medical personnel as well as the hospital. And through our review of the hospital records or medical records, we have determined, forensic laboratory determined a possible case of medical negligence. Thank you very much. We are on time. Thank you for listening.
Thank you. That was an interesting point sharing by Dr. Presida from Philippines, which highly active in advocating for the legal aid for children to ensure they are not left out and receive a legal protection and representation that they deserve. Not even that, there was an awesome points of view and initiative done by the states of Philippines in assisting the children in terms of uphold their legal and human rights. A sharing that can be practiced together, I think, if it is in accordance with the needs of our country next. Then I was told that by Dr. Erwin, the forensic laboratory division in Philippines quite similar with the CSI drama series, isn't it, Doctor? It sounds good to us. Again? Yeah. Too advanced for that, right? Right. Now we move to our fourth panelist, an important person and backbone of Bar Association of Kingdom of Cambodia, and actively playing a role in providing legal assistance, particularly to the poor, and its commitment to upholding justice and human rights. Allow me to share some backgrounds of Mr. Stroon, please. His international engagement of Mr. Stroon is, he managed to contribute by way of drafting rules of procedures for ASEAN Charter and was Cambodia's representative to the ASEAN Intergovernmental Commission of Human Rights from 2013 until 2015, where he helped draft ASEAN legal and policy frameworks for human rights.
Distinguished delegates, ladies and gentlemen, I thank Madam Moderator for the briefing, my biography. Since my presentation rather out of topic for today discussion. The slide PowerPoint here just focus on the Bar Association of the Kingdom of Cambodia. Because in Cambodia, the institution that provide legal aid or pro bono, that is under the Bar Association of the Kingdom of Cambodia. And I just have some friendly discussion with our distinguished delegates during the during the lunch break. Pro bono may be defined in different things, but one common thing is the legal service providing to the people who seek for the service is free of charge. It's free of charge. So legal professor or legal officer of the government may also provide the pro bono services. That is what I'm going to elaborate further for your understanding the jurisdiction from the Kingdom of Cambodia. Before I begin, please allow me a few seconds to convey my honorable president of the Bar Association of the Kingdom of Cambodia his warm greetings and best wishes for all distinguished here, especially for excellent arrangement of Malaysian legal aid departments under the Prime Minister Cabinet, and for the team for excellent organizing for warm hospitality. I look at the time frame given me. Please have me a computer assistant. I just go through with the slide only 5 minutes. And then I have 3 main points to brief, to inform all of you about what is the legal aid mechanism in Cambodia. It's kind of a bit different from what you heard since early morning. So your listening, please focus on me. Just see the slide presentation. Please go on. Please keep going on. Slide. Yes. You know, the Bar Association of the Kingdom of Cambodia is leading, is managing, is regulating all the lawyers' profession in the Kingdom of Cambodia. I'm saying the lawyers' profession, not legal profession. Because legal profession may define like government jurists, like legal scholars, like attorney in their legal profession. But the Bar Association of Kingdom of Cambodia is a single institution that regulates, that recruits, that manages, that lead orders in the entire kingdom, entire territory. We've got about 5,000 practicing lawyers in the kingdom. And the Bar Association is leading by the president and 33 members of the council. Combined together, they meet in the meeting with the majority and lead the lawyer association in the kingdom. The legal aid, we do not have legal aid act. You just heard from Malaysia, from our colleagues from Singapore. But the provision of legal aid integrated into various legislations, like criminal procedures, like the law on the bar, the lawyer statute, and like other law legislation. The provision of legal aid integrated in there. And today, the whole day, I have learned a lot from our colleagues, and I wish to express my sincere appreciation and gratitude for your sharing. With that knowledge, I may return home and brief to my president about what happened in our Asian member states, particularly the ones that presented today. The legal aid played by the Bar Association of the Kingdom of Cambodia is only to provide lawyers to represent, like our colleague called the poor, the vulnerable, the disadvantaged, and including the children. we have a greater opportunity to have good relationship with international organizations, especially UNICEF, like some our colleagues just mentioned this morning. The project that to train our lawyers to be specialized in child-friendly proceeding. We have the juvenile justice law adopted and in practice for about 10 years. But to my views, our lawyers need to have trained more to focus on the child-friendly legal proceeding. In the courtrooms, I am one of the pro bono lawyers, and our judge, prosecutor, the whole proceeding. Yes, some of them may understand about child-friendly proceeding, but somehow we just talk to the children, those who committed crime, those who have some issue like the conflict with the law, in a way that we talk to not more people. So we may have to need more time to learn and to teach or train those justice people to more specialize in child-friendly proceeding. Could you move forward? Yes, in here, in this one particular, our pro bono lawyer stand near to, yes, that is a child, that is in the court of law. So once the Ministry of Justice, especially the courts, propose to the Bar Association, we would provide the lawyers to defend. So on the proposal, could you kind move faster? Continue, move faster. One more, turn. May I introduce you? Return. One more, return one more. This is the building of the Bar Association of Kingdom Cambodia. We own the building. And inside the building, we have auditorium, the conference room, a bit smaller than this, very convenient, where we normally provide legal training in order to elevate the legal talents for our lawyers. Move, continue. Yes, continue. Continue, please. Yes. This is the national law. I mean, some provisions integrated in the criminal codes, criminal procedures, in the statute of the bar, and in the constitution concerning to the rights, the protection and promotion of the rights of child. Now may I return? Forget this slide. Look at me. I have 3 points to introduce you about legal mechanism in Cambodia. That's because legal aid or pro bono play exercise by different ministry. We have the Ministry of Women's Affairs, where we have the National Council for Women, and they provide the legal services and the way to protect and promote the rights of women and girls. That is the National Council for Women and Girls. Sorry. We have some water. We have another ministry, that is Ministry of Social Affairs. Sorry. Where we have National Council for Children. National Council for Children that provide the services that the children need. Like our speaker this morning just provide the services provided by the pro bono system of their respective jurisdiction. In Cambodia, there are about 25 ministries and government agencies. All of them, we have legal department. The legal department served by law graduates, those people, those officers who graduate in law. So the legal provision, the legal services provided to the children or to the needs of women or people in need, that's kind of pro bono, no charge. And we have the Ministry of Justice. Ministry of Justice provides us with the budget for the Bar Association in Cambodia. Once when a lawyer nominated by the bar to represent any child with the legal issue, the Ministry of Justice provides some fund, just the spending for transportation, spending for copy the documents, very little money. And we have the Ministry of Interior. Ministry of Interior, we have the local government. The local government for all provinces, we have 2 special committees in there. The provinces big, the capital city, the provinces, and we have the district, and we have the commune. Commune smaller than district. District smaller than province. The commune, we have each commune, that is the local government, we have 2 special committees. That committee for children and committee for women. So you see, the pro bono services provide from the grassroots, from the local government. And at the local, at the grassroots, we have the representative from the ministry. Each ministry have their offices until the villages, until the communities. So we meet people, meet children and women. And Ministry of Education have adopted 2 policies. That is the child development policy, in order to promote, foster the rights of children, education, welfare, and so on and so forth. And I keep continuing. Now, may I focus on the legal framework and policy. And as I mentioned to you earlier, we do not have legal act, but we have legal provision integrated into different legislation. And I think the commonality of the Asian member state is for the children who have they may commit crimes, or they may become the victims, or they may have the issue of conflict of law and go to courts. By law, there is compulsory legal provision. There must be a lawyer representing the rights of children in all the level of proceeding. The Bar Association of Kingdom Cambodia, we have offices in all the courts. There are 25 provinces and there are 25 courts, and we have 5 regions. There are 5 appeal court, and we have only 1 Supreme Court. All the courts, we have legal lawyer office in order to provide the pro bono services in the court. So it sounds like very unique and particular from what you may have heard since early morning from Cambodia. And we have the policy, pro bono policy, adopted by the Bar Association of Kingdom Cambodia. We have a lot of volunteer lawyers who devote their time and energy for the pro bono. You may not believe, more than one third of lawyers in the Kingdom of Cambodia dedicate themselves for pro bono. You may not believe that, pro bono. That is why some of you may know the history of Cambodia. And like me, I come from poor social background. And once I become lawyer, I am volunteer to provide the legal presentation for the poor. That is our legal obligation. That is our moral obligation to do that. That is in Cambodia. I have about 4 minutes left, but I may finish before time. So may I conclude? The legal aid in Cambodia is provided by various institutions. But the Bar Association of the Kingdom of Cambodia, we have legal aid department. We provide the lawyer. We provide the lawyers. And any lawyers who nominated and go to the court to represent the child rights, who to provide the service or legal presentation, we give them some budget, very small amount of money allowance, just spending for transportation. And I think I briefed you all, and I should, finally, I would like to again express my sincere gratitude and appreciation for the whole convention, and I have learned a lot from all of you, especially from the speaker. Thank you.
Thank you, Mrs. Trun. From your presentation, Mrs. Trun, it seems that many initiatives have been implemented in the Cambodia Bar Council, supported by the Ministry of Justice, and you have a Cambodian National Council for Women's Support for the Public. I was told that the Bar Association Kingdom of Cambodia have a team of lawyers which are actively in offering their support for the poor and needy, especially in a children-friendly environment court proceeding. Isn't it, Mrs. Trun? Yes, thank you for that. Ladies and gentlemen, we try to drag the time until 5. Is it okay for the audience? Okay, we try to keep on track. Never mind. Okay. Now, we are now towards the end of presentation by the panelists. It is natural that after a delightful lunch, just now, the eyes starts to play their role. Okay, getting sleepy, and what more during the talk is normal. But I believe that all of us still want to keep our adrenaline maintained, running with our today's presentation topic. I believe Mrs. Fazlia more than ready to share with all of us what initiatives Malaysia Legal Aid Department provides for the civil and criminal legal aid for the children. But before Mrs. Fazlia presents, allow me to share a brief of a legal experience, because I just yet to finish about the background of Mrs. Fazlia. Previously, Mrs. Fazlia was a deputy public prosecutor in Kedah and Terengganu for 11 years of the experience in human and children criminal cases. And even she had served as senior federal counsel in civil litigation. Now, we cordially invite Mrs. Fazlia to present her talk. The floor is yours, Madam.
Thank you. As the last speaker, I promise this will be a brief. After all, even the gate knows we mustn't overburden the people with too many clauses. Okay, thank you, Mrs. Moderator. Assalamualaikum, good afternoon, and salam Malaysia Madani. Our beloved Director General of Malaysia Legal Aid Department, Datuk Nur Azmi bin Narawi, distinguished guests, respected speakers, fellows, delegates, ladies and gentlemen. I'm deeply honored to be here today to represent Malaysia and speak on Malaysia initiative on child legal aid. Child legal aid isn't just about fairness. It's about protecting their right, their futures, and their voices in a world that too often speak over them. Let me start with the introduction of the Malaysian Legal Aid Department briefly. The Malaysian Legal Aid Department, or LAD, also known as Jabatan Bantuan Guaman, JBG, is the Malaysian government agency under the Minister in the Prime Minister Department, Law and Institutional Reform. We were established in 1917 under the Legal Aid Act 1971 to ensure the justice is accessible to all Malaysians, particularly those who cannot afford legal representation. We provide legal aid along with other legal aid providers coming from the legal practitioners, the Bar Council and the NLAF, the law schools, NGOs, and the pro bono practice. LAD provide legal aid services to Malaysian citizens, i.e. eligible person, in accordance with the Legal Aid Act 1971. We offer free legal advice on Malaysian law matters. We provide legal representation on specific criminals, civils, and Sharia cases. We also facilitate mediation services to our client to help resolve dispute, provide legal companion services, and promote legal literacies and awareness program to the community through legal aid clinics, roadshows, legal talks, leveraging in digital platforms like social media, and partnering with legal professionals. We operate nationwide with branches in all states and serve all Malaysian citizens. Children come into contact with the law in several situations. As object of civil litigation or dispute, as person in conflict with the law, as a victim of crime to a witness. The government placed great emphasis on matters concerning the well-being and safety of the children. Various major initiatives have been implemented by the government focusing on the legal aid and criminal legal aid. Ladies and gentlemen, let me start with the Malaysian Initiative on Civil Legal Aid. When dealing with legal aid in civil matters concerning a child, legal aid for a family-related matters is the main focus here. The best interests of children are the primary consideration in all matters that affect them. Children as object of civil litigation or dispute should be considered as a fully fledged client with their own right, and lawyers representing children should bring forward the opinion of the child. In Malaysia, there are two distinct sources for matters concerning families law. The first, the Islamic Sharia laws, which apply to the Muslims, while several other laws govern the non-Muslims. In both cases, the best interests of children are given primary consideration. We balance with the conflicting interests of an adult. LADs offers legal aid assistance in family matters under the Law Reform Marriage and Divorce Act 1976, which include proceedings relating to marriage, divorce, child custody, guardianship, division of property, and maintenance for spouses and children. LAD also offers legal aid in proceedings relating to the adoption of child under the Adoption Act 1952. When dealing with legal advice and legal representation, we will identify the child client and obtain relevant information on their needs to assist disposition of the case to the best interest of the child. And paramount considerations shall be the welfare of a child. Okay, to provide a faster and more satisfactory outcome for the child client in the best interest of the child, we promote mediation services in case involving family dispute, i.e. in divorce proceeding between parents of the child. This service is available to assisted person, and an assisted person may request mediation from the LAD, and LAD will serve as a mediator, arranging discussion between disputing parties to foster amicable and efficient resolution on their conflicts, including dispute over custody and guardianship of a child. The main purpose of mediation is to encourage parties to communicate and settle dispute. Mediator also provide guidance and procedure on matters concerning children according to the law. And parties who agreed to mediate must conclude a consent judgment for this purpose. Once an agreement is reached with the help of the mediator, the parties sign an agreement in the presence of the mediator, and the term agreed upon will be documented in pleadings. In mediation session, the welfare of the child will be our primary consideration, determining the success of mediation proceeding. Okay, ladies and gentlemen, now I'm moving my speech to talk about criminal legal aid initiative in Malaysia. Children come into contact with the criminal justice system, whether as a victim, as a witness, or as an accused person. They enter a world with complex, intimidating, and often traumatic. Unlike adults, children lack of maturity, knowledge, and emotional resilience to navigate the legal procedure on their own. This is why access to child-focused legal aid is not just necessary, it is essential. The best interest and safety of the child shall be the primary consideration in all action taken and any decision made in the course of criminal proceeding. Given the difficult and sensitive nature of the child sexual abuse, children and their family must be treated with utmost dignity, respect, and compassion. The physical, emotional, and psychological well-being of the child must be a priority, and appropriate action taken to ensure they are protected from further harm, threat, and retaliation. When a child has been arrested or detained, they have a stronger entitlement to legal aid. In those circumstances, the Convention on the Right of the Child, Article 37, specifies that child must have the right to promptly access legal assistance. And the UN Standard Minimum Rule of Treatment of Prisoners, Rule 93, provide that a child who has not yet been tried to be permitted to apply for free legal aid where available. In Malaysia, both the government and the Bar Council offer free criminal legal aid to the children in Malaysia. We both complement each other in providing legal aid in criminal cases, especially when involving children. We also have the National Legal Aid Foundation, known as NLAF or YBGK, a government-funded initiative that provides free legal assistance to advise citizens, including children who cannot afford to hire lawyers, and they focus on criminal matters at the stage of arrest, remand, and trial. Basically, this is a scheme fund the lawyers or the legal practitioner to do their legal work in criminal matters. LAD also provide legal representation for child citizens in criminal defense, particularly in child court. As stated under the second schedule of our Legal Aid Act 1971, likewise the Bar Council likewise the Bar Council Legal Aid Centers and the YBGK also taken the same position and assisted national and non-national children by providing them with legal representation. In assisting children under remand for access to justice, we visited the Child Probation and Rehabilitation Center managed by the Department of Social Welfare in order to provide legal advice and legal representation. What about child as a victim of a crime? In any courtroom, the procedures, language, environment can be overwhelming or even for adults. Now imagine what it must feel for a child or for a victim of trauma, being asked to relive painful event in front of strangers in a setting that was never designed for comfort or healing. Therefore, LAD provide legal companion services, especially specially appointed individual, i.e. our legal officers, who provide legal support, guidance, and assistance to a child during court proceeding, particularly to the victim or witness of criminal cases such as abuse or sexual violence. This service was introduced through the Legal Aid Amendment Act 2017 to help reduce the financial and emotional burdens on families while enhancing their understanding of the court process. Guardian or family of the victim, the officer from the Department of Social Welfare, or the victim himself or herself may approach any legal aid branch all over Malaysia to get legal companion service. Ladies and gentlemen, what legal companion does? Okay. Among the functions of legal companion are: first, we advise the guardian of child victim on legal matters in relation to the crime, clarify stages of criminal process, including all pre-trial proceedings, hearing, and to explain about court proceeding in order to help the child victim and their family to understand what is happening. Second, we obtain relevant information on behalf of victim of sexual crime which related to charge against the accused in criminal proceeding and provide legal advice to victim or guardian about sexual crime procedures, including police report procedures, if it's not already done, police investigation, and court procedures. Thirdly, legal companion also physically accompanies the child in court proceeding and with the leave of the court to speak on their behalf. In short, legal companion will protect the legal interests of a child and act as a comforter, especially during court proceeding. We also offer reassurance and explain what to expect before and during proceedings. And also we advise the guardian or the protector of the aided person authorized, permitted under any written law on any matter relating to any civil action that can be brought or instituted by an aided person, if any. Roughly, the statistic for the years of 2024, only 197 cases of legal companion cases were registered under the LADs, compared to a higher number of total 2,235 cases reported of sexual crime against children in Malaysia. Therefore, it is incumbent upon us as a legal practitioners to discharge our respective duties and right of children who fall victim to such as this heinous crime are afforded a full measure for legal protection. Despite all this framework, gap remain in practice. Many children, especially in rural or low-income communities, still appear in court without representation or understanding of proceeding. Parents and guardians often lack awareness of available service, or frontline enforcement officer may not always know when or how to refer a child for legal aid. Therefore, LAD has been diversifying in community empowerment program in order to create legal awareness on children's rights as follows. First, we have our legal aid clinic, plus we also have a mobile legal aid clinic, which is a Justice on Wheel, and a mobile van that we provide legal consultation by visiting to the rural area or outreach area in order for the remote people to access for justice. Secondly, we do community programs at prison or detention center for children by visiting this detention center on regular basis. Thirdly, we also have a legal awareness or literacy dialogues, talks to school, to university students, as well as to other relevant agencies. Fourth, we also collaborate with the NGOs, the local leaders, other government agencies to educate people on community service and about their legal right. And fourth, we do media engagement and participation in public service announcement. We had our media social platform from the Facebook, YouTube, IGs, and also we have podcasts on Sembang Guaman that we provide promote our legal activities and promote legal talks and literacy to people through media platforms. To conclude, child legal aid isn't just a service, it's a beacon of hope. Every child deserves not only fairness under the law, but also the courage to speak, the strength to be heard, and the unwavering knowledge that they are not alone. Justice is not what we uphold in court. It is what we extend to those with the smallest voice, and it is our duty, our legal moral obligation to ensure that every child, regardless of their background, is heard, protected, and defended. Let us remember, legal aid is not a charity, it's a right. And justice is not truly served until everyone, regardless of their means, can stand equal before the law. For that, thank you.
Thank you, Mrs. Fazlia. It seems that she really loves to promote all of us on the legal companion that we have in Malaysian Legal Aid Department of Malaysia. Maybe I can summarize from Mrs. Fazlia, which on a legal companion in Malaysia is a specialized support service for child victims of sexual crimes offered by the Legal Aid Department of Malaysia to ensure that their legal protection, comfort and assistance throughout legal proceedings. And with regard to civil legal aid for child, the Nation Legal Aid Department provides state-funded legal aid primarily to Malaysian citizens, including civil matters relevant to the children like custody, guardianship, and child welfare applications. Thank you, Mr. Fazla, for that truly insightful and engaging presentation. To be fair, because since we have more than enough time in this afternoon, I will invite all of our lineup speakers, if any, together with me on this the stage. Maybe all of you can share with us furthermore on the programs that all of your country, in order to get engaged with the public, the poor, the needy, the children, to be obtain any legal aid in your country. I believe that Mr. Ashwin, you haven't finished with your slide, or in the last slide just now, whether you want to promote anything on your end. Yes, but before that, maybe we can have you can have from your seat, yeah.
I'm actually
Anything?
done. Can you all hear me? I'm actually done with my slides. So,
Are you finished with your slide?
I am.
Yeah, anything that you want to promote on your end?
In terms of?
In terms of legal aid for the children, especially? Maybe you can share your experience as well.
Sure. I think before going into the legal aid aspect, I was just talking to a particular colleague of mine. It would appear that the flavor of the day is vulnerable. We keep talking about vulnerable persons, vulnerable children, and sometimes I think moving forward, what we'll need to all do is to really work towards it. It cannot just be lip service at the end of the day. I come from private practice before, and we hear these things, we need to help the young, we need to help the vulnerable, we need to ensure we do what we need to do. But sometimes we just don't put our foot down and say, let's do it. So moving forward, I think I'm very glad, number one, I'm at this convention. It really shows that all of us have this united belief that we must do more to help our vulnerable victims and our vulnerable offenders. And I really hope that we move forward, we push this agenda forward, and to ensure that we have access to justice, not just for our adult offenders, but for everyone. So that is really my key takeaway from this convention. I know I do not really answer your question directly.
Never mind.
I don't have the answer, but I
Just
thought
share
I'd say this. Yeah,
any,
thank
you have any experience then?
Yes, I mean, so like I said, when I was in private practice, of course, I tried my level best to do as much pro bono work I could. And a good chunk of them were, in fact, all very vulnerable, accused persons. Amongst them, we have mentally ill offenders and we have very young offenders. So when I came to PDO finally about 1.5 years ago, a good chunk of my cases are also all very, very vulnerable offenders. And I'm glad that, we have the resources and we're pushing forward in ensuring that, they get the proper representation and their voices heard, whether it's in court or whether it's to the prosecutor's ears.
Okay, thank you. It's awesome, Mr. Ashwin. Maybe Dr. Pasida, anything there on your part you want to share with us? Anything experienced during conducting any cases in court?
I would like to inform our colleagues and counterparts in legal aid that next year, in May, we shall be holding, because ASEAN will be held in the Philippines next year, a grand convention, 36-hour mandatory continuing legal education for free to all lawyers in our office. Around 4,000 lawyers and paralegals will be attending for the about 9-day convention at the World Trade Center, Manila. And in order to improve the services of a legal aid provider, the 3 parameters of social development should be employed: transparency, accountability, and the other one, transparency, accountability, and empowerment. empowerment by conducting several trainings and seminars to improve the skills, the quality of services that can be provided with the clients, especially the minors, accountability to remove all erring lawyers and staff if ever after due process and hearing, and of course, transparency. The people should know how the legal aid provider is doing its job, and there should be feedback mechanism from the public. And of course, it is the follow the leader rule. The leader must be the role model of everyone. And maybe that's the reason, modesty aside, why I sustained around 25 years as head of this nationwide agency from 2001. I served 4 presidents from Arroyo to Aquino to Duterte and now to President Marcos, who is now at state visit at Cambodia. He is now in Cambodia for a state visit. So I've been following up all the rules, be a role model, law-abiding, everything. Do your passion for justice. And of course, I started with a budget of only 300 million a year. And now, how much is our budget, Director Latosa? 6 billion, around 6 billion a year, budget of our office. So, I've been speaking in several fora like Legal Aid, International Legal Aid Forum in Japan. I came here for 3 times during the International Corrections and Prisons Association seminar here, Legal Aid seminars here. I am being invited by the United Nations in Vienna. I advocated the principle of independence and autonomy from the Ministry of Justice or Department of Justice so that there shall no perceived collusion between the public prosecutors and the public defenders. Because if they belong to the same department or ministry, the people will just say that prosecutors, defenders are under one hat. So, trust and confidence may be tainted. And that is one principle of the United Nations guidelines in handling legal and criminal and civil legal aid in Vienna, and that was signed by countries of the world, that legal aid providers should be independent and autonomous from the Department or Ministry of Justice. And we won because we had a new act, the Public Attorney's Office new act, our law in 2007. We were given independence. We are only attached to the Department or Ministry of Justice for purposes of policy and program coordination as well as budget hearing. But, don't tell our secretary or minister, there is a perceived still efforts to undermine us, to conquer us, but we should object in a nice manner because my position will be under threat. And we should be media-friendly so that the media can be the purveyor of truth, justice, and equity, and they will tell everybody, here comes an agency who could give an open arms, an arm for you to get justice and freedom. And our office worked for the abolition of death penalty, and also we won. There's no death penalty now in the Philippines. And I argued before the Supreme Court for 4 hours 20 years ago, and we won. So the maximum penalty for every heinous crime now in the Philippines is only 30 years to 40 years. Thank you.
Thank you, Dr. Presida. I'm not too sure whether Dr. Erwin, you want to share anything on your part? Don't be shy. Nothing much. All right. Okay, nothing much on your part? Nothing. All right. Thank you then. Dr. Presida, maybe you want to promote to the audience about your hashtag Pala, and you can increase your followers then.
You may join my followers. Modesty aside, we have 1.55 million followers. Our page under the name of yours truly, Presida V. Rueda Acosta. You can search. And modesty aside, that's a channel now. I don't engage in many media, TV interviews now. I just say what I want to the people at such page. And permit me to post this event at my page to promote Malaysia. And also I've seen the development of your country, the infrastructure, the roads, the bridges, the establishments. I can feel now we are left behind. Philippines is left behind by Malaysia. But we are friends. The first people who went to the Philippines long time ago are the Malays from Malaysia.
I see.
Then Chinese, then Spanish, Spaniards, then Americans, then Japanese. We are melting pot of races. And some of your words, the Malayan language, are part of our words because we are all of the same origin. So I look like also a Malayan or a Japanese, and you also look like Filipinos. So we are friends of the world, and I'm very happy to be with you again on this country, and promise I'll come back to promote your country. Thank you.
Thank you, Dr. Basida. Thank you, Daddy. I'm not too sure on the part of the Mrs. Trun. You have anything to highlight to us and recap for us?
May I? Thank you. May I share with the audience some concept of philosophy, legal aid, access to justice. What justice? What justice? So, with the sense of what we have been listening, we have been doing today, the whole day, justice in here, access to justice, when we go to the courts of law, when we have something difficult to handle with the areas of law, and that all of us say access to justice. Equality before the law. Equality before the law. But we are human beings. In our each jurisdiction, we have the top, the rich, the elite, the aristocracy, the poor, the vulnerable, and disadvantaged. To my understanding, the poor, the disadvantaged, the vulnerable, they are the victims of the society. That all of us as human beings have the moral obligation to provide them the help and assistance. All of us here are mom and dads. I'm also a dad. We need to provide our children for good people. So before the legal aid, before access to justice, what is there? That is the culture. That is the civilization. That is the way we raise our kids, our children, in order to live in the society. We inform them, we teach them their rights and what they should not do. So first, before the legal aid, before the access to justice, that is the role of education. And who play? Not only Ministry of Justice, not only the government, all of us, adults, that we have to care our children, that we have to provide the kind of support for the young generation in order to live one world, one sky. So I come from a long distance just to meet our colleagues here. But we come from different lands, different jurisdictions, but we are human beings. We live in one world. We live in one sky. So we know the basic needs, and how can we do? So legal aid, access to justice, equality before the law, and everything. That's, we have the part. All of us have a part to play. Not the role of the legal aid department, the government, but all, the whole society. Thank you.
Thank you, Mrs. Trun. But unfair if I'm not giving the same opportunity to our Malaysian speakers. Mrs. Fazlia, anything on your part? Anything to update or anything to share with the audience?
Okay, concerning Legal Aid Act, child, especially to the child, and to ensure that children in Malaysia, not only just Malaysian, to receive legal protection with the law, the Malaysian government is moving forward to more child-friendly justice system by the new bills 2025 lah. So the new bill is passed by the Dewan Rakyat in August 2025, and it is approved by the Dewan Negara in September 2025, marking a full legislative passage to justice lah. So the Legal Aid and Public Defence Bill 2025 is currently in progress. We aim to broaden child protection effort on legal aid initiative by including the introduction of automatic legal representations, at least for all children and victims of crimes, regardless of their citizenships or status. It's also outlined to improve coordination between legal aid department and enforcement agencies to better serve the public. Legislation alone isn't enough. We as a legal practitioners, we carry responsibility to bridge the gap. So to educate, to advocate, and wherever possible to serve, whether through pro bono works, policy reforms, or community outreach, we each other have a role to play, and in shaping our legal aid systems that live it up to its name lah. All right, for that, that's all one. Thank you.
Sure. That's why we have a forum like this, right, Mrs. Ruth? Yeah, I believe we have more time, more than enough time. And I now open the floor to have any questions to any one of us.
Good evening. My name is Charanjit. I'm the Senior Legal Officer from Penang. I spent the first 7 years being a Deputy Public Prosecutor. I realized many legal aid scheme, it's tied to the means test. That means you need to be in the means category before you can get legal aid. But I think the means test has become a hindrance, because if any members of the society approaches for legal aid, they need help. So do you think that it is time for us to move away from the means test, not follow it strictly? Because if people can afford legal advice, they will have gone for it. But whenever anybody comes for legal aid, it should not be a hindrance because they did not fulfill the means category. For this 21st century, I think that is something that we can look upon it. So my questions to the distinguished speakers is, what is your opinion of the means test? Should it be open now, or should we still follow the means test? Thank you.
Sorry, sir, do you have any specific speakers to answer your question?
I do not have any specific speakers. I think it's open for all.
Okay then. Any one of the speakers can help to answer the question?
In the Philippines perspective, we have our operations manual, wherein we have the so-called income test. If you are jobless, no income, automatically you can be our client. Free legal aid, no cost to client. But if you have income, we have a threshold. In Metro Manila, your income should not exceed the net, meaning less deductions, less loan, your liquidity. 24,000 a month. In other cities, 22,000 pesos a month. In other municipalities, 20,000 pesos a month. But the court can appoint us as counsel de oficio for emergency situations wherein taxpayers have no private counsel, and we can extend immediate temporary and provisional service until such time the taxpayer can get his own private lawyer. So the Philippine laws and our office is filling up the gap. Nobody should be left behind. Everybody should have a lawyer. Even during custodial investigation, interrogation, and upon arrest, there should be a pro bono lawyer, a public attorney under our office who will attend to your needs. Because of the due process clause of the Constitution, no person shall be deprived of liberty, property, without due process of law, nor anyone shall be deprived of the equal protection of the law. Every constitution of the world has such provision. So we are advocating anywhere in the world that pro bono lawyers should be provided. If there are no pro bono lawyers, the bar associations, the law schools, the paralegals can extend pre-legal aid subject to tax deduction. There's a law in the Philippines like that. You can avail tax credit as a private lawyer, giving your time and effort to a pro bono case. Thank you.
I see from the floor there is a madam want to pose any question for the, but then allow me any of the speaker want to answer about the means test about, how about from the Cambodia? Nothing much. How about Malaysia? Sorry, madam.
Okay. Thank you. Regarding the mean test, we at the legal aid, we also has the term what we call eligible person. When we talk about eligible person, is they have to meet certain criteria, including in our Malaysian legal aid department, we have two tests. There is a means test and a merit test. The mean test is that applicant must not exceed specific income and asset threshold to qualify. For the time being, asset threshold is for the person income yearly 50,000 or below. Then they are qualified for our legal aid. And the case also must have reasonable ground to legal action to be guaranteed aid lah. After passing both tests, we will provide a certificate for them. But there are also subsidized service to the public. Means that person with income more than 50,000, they also can get legal aid service under the LADs, but with a certain deposit that they have to pay to the LADs. We also provide. But our threshold is until 70,000 per year. Above 70, they have to get consent from the minister for the legal aid services from us. Thank you.
Okay, thank you. How about Mr. Ashwin? Do you have anything to share about this work? Nothing. Right. Okay. I can invite Madam to pose any question.
Good afternoon to all distinguished speakers. My name is Anne Baltazar from Anak Sabah, an NGO. So my question is, philosopher Hannah Arendt spoke of citizenship as the right to have rights, where in reality, a child is accorded rights by the country that it belongs to. And for stateless children, and I'm specifically from Sabah, whether they are indigenous or sea nomadic, such as the Bajau Laut who roam the seas of Indonesia, Philippines, and Malaysia, as well as children of mixed marriages. For many of them, they still do not have access to even basic rights. I applaud the government for the recent amendment of the law for legal aid for children. However, what do you think? Who should be the duty bearers to the rights of these children as well, and what could ASEAN cooperation on legal aid for children look like, specifically in helping these children secure a legal identity and resolving their statelessness? I think it's open up to any speaker who would like to answer. Thank you.
Thank you, Madam. I think a question is about the children with no identification documents. Is it the gist of your question?
So stateless children, which means they do not have a citizenship to any country. Yeah.
Okay, any one of the speakers can help to answer that question. Do you have do you encounter any experience on that? Or maybe I can open to the floor if any one of us have any experience on that.
Thank you. I think stateless in regarding of the children, because even when of system, because some of country adopted of Yusangunis and then Usol, or some other country adopted both of systems. But in according of my home country, a lot of, because the new development country, we ensure is accepted every citizens come from the abroad. And then these circumstances is very difficult thing to every democratical countries to avoid for this circumstance. But even in according of the experience of my experience self, because the children has no choice. In according of international conventions for children rights, UN and every United Nations member have obligation to protect until the proceeding of the legal procedure, because I don't think so in Malaysia or the other countries, but in my in Timor-Leste, we are aware even the national legal framework aware these circumstances, but we still have obligation, and then tribunal or the court in East Timor to be considered of the international instrument to be accepted in the legal framework in East Timor. I have to ensure that these circumstances also be aware for each country when they adopted and then to ratify UNCRR. Thank you.
Thank you for the answer from Mr. Pensio. Maybe anyone from the floor want to share experience about the stateless children? Yes, our Datuk KP.
Regarding the stateless children, first of all, this involves serious question of policy to be decided by the government. So I believe it's not proper to discuss on stateless children.
Okay.
But however, as far as legal aid is concerned, we already amend the law to provide necessary legal aid. But whatever the legal aid, only confined to what we have in schedule, being the jurisdiction of our legal aid in the Act. So, for example, like on a nationality, that is beyond the jurisdiction of legal aid. So we cannot provide that. Why? Because when we talk about stateless children, we are talking about the principle of jus soli. Jus soli is not applicable in English. That's why I want to respond. Stateless children. Just one thing about West Charanjit. About the means test, I just want to say, because all of us some of us are lawyers, why we cannot even increase the capping from 50,000 to 100,000 or make it open, because we must maintain the market for the private lawyers. If everything is subsidized by the government, how the private lawyers cari makan gitu apa? You are killing the business of private lawyers.
Earn money.
That's why the justification will be based on the reasonable classification, mean we tie with the income.
I see a few questions from the Slido. My mistake because I'm not promoting the Slido just now, but I can read few questions that can help the floor to resolve their questions. Yeah, maybe the first question. To what extent do you think that schools can become part of the legal aid ecosystem to support child's right in both civil and criminal contexts? Thank you. Dr. Pasida, do you have any program in school?
I would like to answer the questions in accordance with Philippine setting.
Yes.
The first question, yes, schools are part of giving protection to our children. So our lawyers, our pre-legal aid lawyers, conduct school visits to explain to the teachers and the officials of the school about the legal rights of our children and even the rights of the teachers. Because in the Philippines, we have the anti-child abuse law. Unlike before, the teachers can castigate, discipline the students, no? But now, no, you cannot inflict any injury or verbal abuse among students. So both sides, the teachers, the parents, as well as the children, should know the rights, the extent of the rights. And then how to ensure that your legal aid system is child-friendly. Of course, there should be an advocacy of separate cells or separate facilities of the children among the adults. There should be several facilities. In the Philippines, with our government constructed several homes for the children. So that should be done. Because if ever the children will be mixed with adults, they will be getting or, be infiltrated with some ideas which are not suitable to children. And then, can children obtain service from legal aid without parental consent? That's basic. By virtue of parents' patria doctrine, meaning parents' patria doctrine, the state is the guardian of the welfare of the people or the child. These children, but without parents or without consent of the parents, should be afforded with pre-legal aid. Because they have legal rights, they have human rights, they are human beings. So even though sometimes the parents themselves are the perpetrators, the rapists or the abusers, so the state should provide legal aid to our children. And then, what's the other one? And then, what role do partnership with government agencies, NGOs, pro bono play? You know, our office has many memorandum of agreement with several NGOs, GOs. Our office is a favorite of everyone. And later, I already told some entities that just refer cases to us because as if our office is their office. So I've been telling them, just refer to us, any case, and they will attend to the case. And you know, our lawyers, most of our lawyers just stay for 5 years, 10 years, because of being overwhelmed. They transfer as judges, justices, prosecutors. So I'm just a teacher for more than 24 years. I'm a law professor since 1990, but I just resigned and took a leave because I've been a teacher. I'm the teacher of all lawyers in our office. That's it. You have to train lawyers who could be pillars of the justice system. Because our lawyers will not stay long unless they have passion for justice. They have passion to be a pre-legal aid lawyer. So that's it. Everyone should be sensitive with your responsibility. If you enter government, you should work. You should be persistent. You should be passionate. Otherwise, you just be a private lawyer. But if you're a public lawyer, it's your duty, sworn duty to God and to the country to work. And your passion can be felt. You don't need to say, I am passionate, I am persistent. You don't need to say, just show your work and the results of work, and everybody will support your advocacy. That's why I was able to stay long in this office. My rank when I was appointed is just an undersecretary, a salary grade of 30. But after 4 years, when we worked for the abolition of death penalty, the President of the Republic promoted me to cabinet rank. I am a minister rank. But I just act like an ordinary public servant. You should be humble so that you will be loved by everyone. Thank you.
Okay, thank you. I'm not too sure, Mrs. Rune. I think you can help us to share about pro bono or volunteers, lawyers in your country.
I see some questions very important, and we should share and discuss the role of schools in order to provide child's rights, both severe criminal context. In Cambodia, you are teachers, you are university professor. The society respect you. And we have like every year we have 1 day dedicated for teachers and professors. And we honor teachers and professors who provide education for our children. And all of us come from schools, and we are sitting here. And to my views, students at high school, before they finish high school, there should be some subject about law. Yes, all of us are taught about the principle of right and wrong. But the principle of law sometimes a bit different more than that. That's right, but the law say wrong. That's very particular, but then many particular of that kind. And that's why teachers, professors at university play crucial role in order to provide a pro bono. Like I just share some thoughts, some thinking, some views from our distinguished colleagues here. And you know, child-friendly legal proceeding. All lawyers, we are adults. Yeah, we come from childhood. So somehow we may understand ourselves, the need, the young, the minors, the children. But that's kind of technique from the experts on the child rights. In Cambodia, we've got opportunity. We have good relationship with the UNICEF. UNICEF, they have experts who know how to provide, how to encourage us to think, encourage us to act in a way that our colleagues here mentioned child-friendly manner with children, with the minor who have the conflicts with law or who may become victims or they commit crimes. So I'm responding to the question, but we need times. Because as humans, we have the normal behavior, like to dominate. The old dominate the young, that's human. The big country dominate the smaller one. So that's why some of us just mentioned, in the ocean, the big fish eat the smaller fish. But how can we do? That is the spirit of rule of law, that we can provide some kind of equality. But I don't think equal. Nothing equal in this world. But somehow we may provide some level of justice that we can accept. That is the spirit of rule of law. Rule of law is a vision that all of us, all of the country, all of the governments have to go to. But no country in this world have 100% rule of law. But I may say from Cambodian society, that's because of the rule of law, we are here today. the development, social development, economic. And our government for this legislature commit to the legal reform, like the institutional reform mentioned by our colleagues in Malaysia. That is the spirit of rule of law. I thank you.
Okay, thank you, Mrs. Run. Mrs. Fazla, anything to?
Okay, I saw a few questions about Legal Aid Department of Malaysia. First is about legal statistic. I do not have in my hand now statistic, but in our department, we do the mitigation process for the criminal cases. So most of the mitigation process in legal aid, the cases we resolve about 1 or 2 times going to the court, and then the case will resolve. Most client from the especially from the child, from the probation center, when we took their cases to aid them to represent them in court, and we do mitigation process for them, and basically 1 or 2 times going to court, the case will resolve. So we don't take any longer time. But okay, now I saw a question regarding parents, parents consent of parents to get legal aid for children. Okay, in our legal aid department, to get civil legal aid, we still have to get their parental guardians. But in criminals or legal companion, other from parents or guardian, we also accept cases that is referred to us by the welfare department, by the protector officer, and also cases for legal aid representation in criminal from the welfare office. That is a child which is under remand, that is be detained in the probation in the centers by the welfare. So other than for the criminal, we do have legal aid even without their parental consent. Thank you.
Thank you. It seems that participants in the afternoon really active with these questions. I'm not too sure whether we invite the last question from the floor before we conclude on the Slido questions. Yes, I see from the, at the back. Yes, madam.
Good evening. I open these questions to our distinguished speakers. As we know that the criminal cases, especially the sexual cases involving a child, is now very alarming, regardless whether they are the offender or the victim. So my question is this: do you think that it is time now to promote and appropriate law education to become as a syllabus at their early stage of education in order to make them, the child, understand what is wrong and what is right for them? That is my question. Thank you.
Okay. Maybe Mr. Ashwin, do you have anything on that?
Yeah, okay. Thank you for that question, madam. I think I can only speak for the Singaporean experience. I don't think I'm privy to speak about the other countries' experience. But at least in our country, my understanding is that we are, and we have been doing this for quite some time in terms of sexual education. We have already started talking about what is consent, what is valid consent. And just to give you an idea of why I think the system is working, because a number of my clients who come to me, and these are adult offenders who have been charged with either raping their daughters or their nieces and etc., they get caught because of the child understanding what had been done to them through the education system. So it is when they go through the sexual education course, that's when they realize, oh dear, this is what my uncle did to me, this is wrong. So I think you are right in the sense that we should start doing this, because not only does it empower complainants to come forward if something has happened to them before, but it also tells people, would-be offenders, I say the term would-be offenders very loosely, I use it very loosely, but it also puts them on notice to things like you should not do anything without someone else's consent. So I think we should, and I'm glad that in Singapore we're doing this, and if it's not implemented elsewhere, I think we should start talking about that as well.
Thank you. Before we end, maybe I can allow me to invite our Director General of Malaysian Legal Aid Department. Do you any have curiosity on your part?
Just one issue just now, Mr. Tiris. In your slide, there's a photo, a young man. I'm not sure whether already 18 age of majority or still minor. What attract me just now? Because his, I think, the left hand actually handcuffed. Actually, my question like this. Because in Malaysia, under our child side, I can't remember section 83 or something, maybe Dr. 84A, where we are not allowed to handcuff a child unless and until the offense is very serious or he's uncontrollable. Meaning to say, likelihood he may act dangerously that may harm other people. But the thing is, I just want to ask Mr. Stiris, even doctor and also from Singapore, what is the real practice in your country as regard to child excuse, whether they are allowed to be handcuffed? And then how about wearing the lock-up dress? Because in Malaysia, because I was a magistrate before, for 8 years. Normally, we will not allow the child to be handcuffed, to be kept in a lock-up, stay with the adult, as well as to wear a lock-up dress. So maybe we can share on something on that.
No, that's not allowed by the law. We have the law on juvenile justice, adopted almost 10 years ago. That law drafted with technical assistance from the High Commissioner of Human Rights of the United Nations in the country. And through public deliberation, and in accordance with the Child Rights Convention of the United Nations and other principles like Universal Declaration on Human Rights. But last night, before I went to bed, I found one provision. The last resort, that child that after their age of 14, after 14 years of age, in Cambodia context, different from Singapore. 18, that is the age adult. Minor before 18. So if that particular child age 16, there may arrest or detention. But very special case, the last resort. And the juvenile law, juvenile justice law prohibit no handcuff. But and you see in the photo one of my presentation slide, the child just stand in the court, but they are after 14, follow, accompany near to a lawyer there. I understand your question.
My answer in the Philippines, it depends on the age and the nature of crime being accused of the child. If the case is murder and the child is violent, this should be, it is but fair to restrict his mobility because he might commit anything else. If he's under the influence of prohibited or regulated drug, we should protect the state. Okay? But if the child is just being accused of a very light offense or forgivable offense, they should not be handcuffed. So it depends. And our criminal responsibility age is 15 and below, no crime committed. 15-year-old and one day, they will face court trial and diversion. And that's the development in the Philippines. I've been saying, the result of the efforts of UNICEF to our country and UN bodies about the Declaration on the Child's Rights. And we have the new law, the Juvenile Justice Welfare Act, or Republic Act 9344. So what is important is the human rights for the humanity. Humanity, we should protect humanity. If there should be a danger, we should enforce a reasonable means to restrict that offender to protect humanity. Thank you.
And I think one issue. Institutions good, laws is good, but the issue is law enforcer. Law enforcer, the person that have to be more honesty and loyal with the son of humanity, the law enforcer. I think this particular issue not only any jurisdiction of our country, that the common issue, law enforcer.
Mr. Ashwin, do you have any experience to share about the handcuff for the child?
I think beyond that, I thought was quite fascinating was under the Children and Young Persons Act, putting aside the handcuff issue, is that we do not use certain terminology when we are dealing with our child or the young offender. So words like conviction, words like sentence is never used in the courts. So I thought that was something that is quite interesting because I think at the end of the day, we do not want to stigmatize the child with such labels. And yeah, so I just thought I want to share that with the floor. Thank you.
All right, thank you, Mr. Ashwin. I think we have a very proactive audience in this afternoon. In the same time, I think that all of us are overwhelming with information and sharing from our expert panelists today. With that, that's the only time that we have. We apologize not being able to continue with the Q&A session. Thank you all for the truly engaging and enlightening conversation. We have covered a lot of interesting sharing and thought today. Each panelist, yes, thank you again for the time and expertise. Thank you for the audience for the excellent questions and attention for this afternoon. But allow me, ladies and gentlemen, before I end this session, to give a one pantun or quatrain in English. Usually pantun will consist of poetic verses and it's quite familiar in Malaysia. Okay. But not to worry, ladies and gentlemen, because I have prepared English pantun for all of us to enjoy my pantun. Allow me. Some small fishes are swimming at dusk, flocking in groups among the reed. A warm grateful from all of us, especially to you, the widest indeed. With that, I conclude this afternoon session with wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh, and warm regards for all of you. Have a good day ahead and enjoy the stay in DESARU Johor. Thank you. Maraming salamat po, som aungkun, and terima kasih. Back to you, our gorgeous Mr. MC.
Thank you very much, Walang Anuman. So thank you very much, our moderator. We'd like to have our moderator and our speakers for a group photo. So can we have our photographer to get ready for a group photo with our moderator and speakers? Right, we'll begin with formal pose first, as usual.